Hi, this is Rhonda. If you're viewing this video, it is because our not-for-profit loss mitigation legal clinic has not been able to get your lender to approve your home loan modification request that we submitted on your behalf within the statutory timeline as mandated by both state and federal dual tracking laws. Please understand that both federal and state dual tracking law mandate your lender provide us and you a fair review with a timely response to our federally chartered 501c3 nonprofit loss mitigation request for foreclosure alternative assistance that we submitted. Have been following up and have been documenting your lender's noncompliance for you. You see, once your lender received our complete loss mitigation file from our not-for-profit 501c3 organization, they were to, by law, comply with the following. 1. Provide us with an acknowledgement of receiving our file. 2. Send us or you a notice of any deficiencies in the file within 5 days of receiving the file from us. 3. Provide and advise us of a specific point of contact person assigned to your file within 21 days of receiving our file. 4. Provide a clear response to our request for assistance no later than 30 days from receiving our file. 5. Provide all documentation requested in our qualified written request for information within 30 days. 6. Provide us an accurate and updated response to the debt validation demand within 30 days. If you are watching this video, your lender more than likely has missed the statutory timelines on some or possibly all of the above mandates, creating a documented violation of your homeowner Bill of Rights. This is a very important thing to know because we have also concluded that your current lender that more than likely may have rejected you for assistance before you came to us that we sent our 501c3 nonprofit legal clinic's loss mitigation package to is actually not the current owner of your mortgage loan. They're only the servicer. Like a glorified collection agent that is simply acting on behalf of the true owner of your mortgage loan. So, either you may have been denied or ignored by only the servicer of your loan, and we have reason to suspect that the true owner of your loan may not really be fully aware of your intention to retain your home. It's also very possible that your servicer's denial or lack of response could be caused by a disconnect between your servicer, you, and the owner of your loan. It may be that your file may not quite fit the guidelines provided to your servicer from the owner of the loan, and the servicer simply cannot make an exception. But the owner of your loan can, in fact, make any exception they chose because it's their loan. They own it. Because you have made the decision to bring in the owner of your loan directly into the resolution process through a judge's order by naming them as a co-defendant in a civil action against your lender and the owner of your loan. You will now be 100% confident that the true owner of your loan will be provided with your request for assistance to avoid foreclosure and to preserve your right of homeownership. You will know from the horse's mouth directly and not just the servicer's opinion. By now, you should have already been provided this sectionalized limited scope representation graph that shows you that we are not in any way recommending you to an attorney with the intent to take your lender all the way to a jury trial that could cost you $80,000 to $100,000 to make it to a trial. And even if you won in the lower courts after spending $100,000 on attorney's fees, your lender would take it to the appellate court that could be 3 times more expensive than the lower court. And if you won in the appellate court, your lender will take the case to the California Supreme Court. They will without a doubt win by outspending you. For this reason, we want to make it crystal clear that we are not referring you to any law firm to take your case to a jury trial. Especially because as a matter of court procedures, if you are going to a jury trial, the judge would make both parties participate in a forced mediation just before the jury trial anyway. Almost 100% of these types of cases resolve through some sort of settlement and never make it to a jury trial. The only reason we are recommending and referring you to an experienced real estate foreclosure defense attorney is not to have a jury trial, but simply to enter early potential settlement discussions with the right party, the true owner of your loan, not just the servicer, by naming the owner of your loan as a co-defendant in your homeowner bill of rights lawsuit. Instead of having to pay $100,000 in attorney's fees to be in a court-ordered mediation to discuss a settlement just before a jury trial, the experienced law firm we will be referring you to has a specific proven strategy to hopefully push or delay costly and expensive discovery, depositions, and other legal motions to the back of your litigation process and seek to enter into early mediation or settlement discussions directly with the owner of your loan through their attorney and yours. Your mortgage loan was more than likely originated to be placed in a mortgage-backed securitized trust that was set up as an investment fund that was sold on Wall Street with very stringent rules, regulations, and bylaws that may clearly spell out exactly what can and cannot be done on a defaulting loan. It doesn't take spending hundreds of thousands of dollars in attorney fees to find out from the owner of the loan just before a jury trial when an experienced, seasoned foreclosure defense attorney working closely with an experienced loss mitigation team can obtain that same information directly from the owner of the loan's attorney very early in the litigation process. Remember, our primary goal is to help you avoid being foreclosed upon, then possibly getting evicted and not being able to purchase or even rent another home because of the horrible process of foreclosure. In some instances, the lender may even seek a deficiency judgment against the homeowner that was foreclosed upon. Our primary goal is to preserve your right to homeownership without you having to go broke to do so. Although it is imperative for you to be made aware that we are not fortune tellers and in no way can anyone here provide you with any guarantee or exactly what the owner of your loan will or won't do. We can, however, assure you that the same exact legal team that have successfully and quickly secured loan modifications for clients, we've referred them that were in default fighting foreclosure for 10, 14, 16 years without paying their mortgages. They have even been successful in reversing many trustee sales, returning homes back into the names of the homeowners that were already foreclosed upon, and then obtaining loan modifications for them. The exact same legal team and their legal strategy is who we are now recommending to you. Now, in addition to making sure you clearly understand that the main reason we are referring you to this law firm isn't to have any type of long, expensive jury trial. It's only to ensure that the true owner of your loan is involved in a potential settlement discussion with your attorney as early in the litigation court process as legally and humanly possible. Then once your attorney and the attorney that will be representing the owner of your loan, not just the servicer, finish discussing all possible and allowable settlement options in return for you dismissing their client from the lawsuit, you will hopefully at that time give your attorney authorization to accept the terms to avoid being foreclosed upon in exchange for dismissing your lawsuit against the owner of your loan. Keeping in mind that as long as it's sustainable, we will strongly recommend you accept it as it will be better than getting foreclosed upon. Remember, you've already given our organization and our alliances the first right of refusal to your next mortgage and/or real estate transaction. So as long as you are allowed to keep from being foreclosed upon, we can help you fix your credit so that you can get qualified for a prime rate refinance or possibly even upgrade your home after you've cured your default, avoiding being foreclosed upon. There are also a few other points we want to ensure you are fully aware of. 1. A lawsuit by itself, once filed, doesn't necessarily keep a lender from foreclosing. Many homeowners, while in court with a novice or sloppy counsel, have been and will continue to get foreclosed upon. One will need a well-drafted lawsuit with provable and well-documented causes of action, along with a temporary restraining order granted by a judge. 2. A temporary restraining order, or TRO, is just that, temporary and must be approved by the judge. Often, this serves as a legal strategy to push the trustee's sale date long enough to have the attorneys discuss a long-term solution. When and if a TRO is granted, there will be another future hearing for longer protection, but often your lender's now court-monitored adherence to the Homeowner Bill of Rights and attorney settlement discussions typically help resolve the matter at hand. 3. Depending on your county and remaining days before the trustees sell, some courts are taking much longer to facilitate the lawsuit filing and provide your attorney with what will be needed in order to file the TRO. So it's wise to have a backup plan in the works to buy more time if any unforeseen issues arise, such as weather or unattainable court dates. 4. The only 100% surefire guaranteed way to ensure your lender doesn't foreclose on you, if you have the ability to, is if you're within the 5-day mark from the trustee sale. If you are able to and have the means to pay off the defaulted loan, you should. If you're further out than 5 days from the trustee sale and you're able to fully reinstate the loan, then you should reinstate your loan. Any other efforts will come with some degree of risk and cannot be guaranteed. 5. The law firm that will be recommended to you to file a civil action in state court against your lender and the owner of your loan to open up potential settlement dialogue in exchange for dismissing the case does not practice bankruptcy protection, but they can and will refer you to an experienced and competent attorney should you want them to. 6. Although their legal litigation strategy has been proven time and time again for literally hundreds and hundreds of clients, some in more dire circumstances than you may be in, there is still a strong recommendation to always have a backup plan to preserve your right of homeownership. No one, no attorney or non-attorney can guarantee anyone what the final outcome of any future negotiations will be. We are more than confident that once the attorney that will be representing the owner of your loan contacts your new attorney as a standard court procedure, your attorney will easily pursue the decision maker, discuss an early settlement that makes sense for both parties in exchange for you dismissing the lawsuit against them. The most common and easiest settlement we typically see our clients are offered by the owner of the loan through litigation is simple restructured loan terms, meaning a loan modification that their agent, the servicer, previously denied as they may not have been able to make the necessary exception that the owner of the loan can easily make. By now, hopefully, you fully understand and are in agreement as why our not-for-profit 501c3 loss mitigation legal clinic has recommended you to an attorney to give you every chance to retain your right of homeownership. If you agree with this recommendation, simply click below giving us permission to have a state bar licensed and experienced foreclosure defense lawyer start reviewing your file and contact you.